Good morning.
Okay, great. Good morning. So hello, everyone. Sorry for the delay. Well, good morning to those in India and good afternoon to those joining us from Australia. So it's great to have you with us as the Chamber begins a new series of webinars. And we're happy to partner again with our member SKP for this one. So a big thank you, first of all, to our three speakers, Krishna Anand, Margaret, and Manuraj, and to Viral and Jugal from SKP, and Manisha, our office manager, for helping organize this. So I'd like to start off by saying that there's plenty of information on the Personal Data Protection Bill, and you'll get to hear more about that soon. But what we've tried to do differently here is to bring you not just the key highlights of this bill, but also different perspectives, catering to both members in India and Australia. So I really hope that this will be an insightful and a practical session for you in your business. We have a really great lineup of speakers today, as you would have seen from their profiles that we shared. So we have Krishna Anand, who is the Chief Information Security Advisor, SKP Business Consulting. And Krishna Anand will be decoding the bill for us, highlighting the key features and its impact on different industries. We then have Margaret Fo, a great combination of an Australian lawyer and the founder of an Australian business in India. So Margaret is founder and chief executive officer of Synapse Medical Services. And then we have Manuraj, who's partner Ganesan and Manuraj Legal. He is also a spokesperson for DMK, and he is steering committee chair for the Australia-India Youth Dialogue, and a really bright and sharp mind. So with that, I'd like to also say that our speakers, will be highlighting key points, keeping it relevant to about 7 minutes each. And after that, you'll get an opportunity to ask questions. So do make note of the questions that you have along the way and share them during the audience Q&A, as that will be relevant to other attendees as well. So with that, it's time for me to hand over to our first speaker, and that's Krishna Anand. So Krishna Anand, over to you now.
Good morning to all. So today we will speak about the India Data Protection Bill. This has created a lot of flutter in the market already, and there are areas of concern for everybody involved in this bill. To understand the implications, what is so different about this bill from the existing data protection laws that are already there globally, privacy and data protection laws. So we'll dwell on this, and I'll take you all through it very quickly. So a quick introduction to the bill. So as we understand the bill construct, there are 5 grounds for processing of sensitive personal data. There are 4 rights offered for data principles. The bill is made up of 15 chapters, 112 sections, 67 pages, and 7 exemptions. 3 months is the date mandated for appointment of a data protection authority that would be established, which would drive the rules, the guidelines, and the guidances, and also be a quasi-judicial educatory body for defining penalties, etc. under the bill. There are 11 measures to ensure transparency and establish accountability, and there are 6 grounds for processing personal data. The bill is applicable to both government and private entities. It also has extraterritorial application. So any business that is carried out in India and any data fiduciary containing or carrying information of Indian citizens will need to follow some regulatory compliances as is necessitated for transfer of data outside India. Personal data is broadly defined. The definition is kept generic by intent. So any data relating to a natural person, directly or indirectly, it is identifiable, having regard to any characteristic trait or attribute, any other feature of the identity of natural person, whether online or offline. So it is not only electronic, but it is also manual documentations. If that relates to a person and it is clearly identifiable, one needs to be aware of that as personal data. Shall include any inference drawn from such data for the purpose of profiling. So anyone who is a critic, who is having some specific attunement and is able to communicate through blogs, and reading his blogs, you're able to identify an individual, then the writings on the blogs are also considered as personal. Sensitive personal data, the following are the categories, especially financial data. In this is something which is highly unclear as of now as to what constitutes financial data to be part of sensitive personal data. Besides that, you have biometric data, genetic data, sex life, official identifier, so on and so forth. There are two grounds for processing. The legal grounds, you need to have a lawful consent. It should be for legitimate business interests. There has to be legal obligations which drive you to collect what you are collecting. It should be in public interest, and there has to be a contractual necessity for one to collect data. The legal ground for processing sensitive personal data is restricted to explicit consent alone. So we cannot assume the consent, it needs to be explicit. Data controller or data fiduciary, as has been defined in the bill, is accountable, has storage limitations. That means data needs to be stored in India. Personal data and sensitive personal data have to be located in servers that are in India. Transfer of personal data is allowed outside India, provided appropriate permissions are taken from the respective data protection authority. Sensitive personal data currently cannot be transferred outside India. Obligation also means maintaining accurate data, providing legitimate privacy notices, limitation of collection, and limitation of purpose. Data fiduciaries also need to establish systems where they carry sensitive data of children, and there is something defined as guardian data fiduciaries who are supposed to verify with a identifiable verification when they are collecting children data to validate it. Data principal has right to access, right to correction and erasure, right to data portability, right to be forgotten, right to be informed, and he has a right to request for his information in a readable format, which can be taken forward or transferred without any commercial charge or fee. Data principal can request, and the request, whatever he requests, it has to be free of charge. The communication of that request has to be adhered through mail or electronically, and data has to be in portable and usable format. He can also request for deletion of his data. There are some exceptions. The exceptions are when you use the information for a financial transaction, when it's part of a security incident investigation, when these data has been used to identify and debug some errors or glitches. It is used for scientific or statistical research. The data is collected as compliance with legal obligations. Example, KYC that is collected for opening and operating bank accounts in India, or it is something which is purely for internal purposes and the employee concerned had given explicit consent for the same. Data fiduciary, there is a prohibition on processing personal data unless it is lawful. There is a limitation on the purpose of processing personal data. So data needs to be collected in a fair and reasonable manner. It has to be used for the purpose for which it is collected. And there is a limitation on collection of personal data. So as much as is relevant is something which needs to be taken care. So, universe of data fiduciary obligations. So he needs to have a redressal mechanism. He needs to have the details of the entities to whom personal data. He needs to have the source very clearly put. He needs to have a procedure for withdrawal of consent. He needs to categorize his information. Very clear details of fiduciary and DPO are required to be displayed. The period of data retention needs to be put forth to the users, and the purpose of collection and the procedure for filing complaints has to be very clearly established. It has to be transparent and communicated appropriately. Further obligations on the quality, restriction, accountability, and consent is necessary where sensitive personal data is involved. Few exceptions where central government or the data protection authority can give that exception to the data processors. The exemptions could be for research and statistical purposes also. The exemption could be for small entities depending on their turnover, the volume of personal data processed by them, and government is also mulling of setting up a sandbox for artificial intelligence, machine learning, and other fields of innovation where personal data can be pseudonymized and used. So, some key steps that an organization needs to take: you need to have a privacy by design policy, you need to conduct a data protection assessment, you need to maintain appropriate data risk registers, a data protection officer needs to be appointed, and you're open for data audits in India, which is very different from the other privacy data obligations or regulations worldwide. Significant data fiduciaries still need to be defined by data protection authority once it is set up. There is social media intermediary, which is by default defined as a significant data fiduciary. Restrictions on transfer of personal data outside India. Critical personal data and sensitive personal data is not permitted to be transferred outside India. Personal data can be transferred provided serving copy of that information is lying in servers within the territory of India and appropriate permission and methodology of seeking permission as defined by Data Protection Authority is followed. Data Protection Authority is considered the ultimate authority in this bill. He has been given unlimited powers, and he has also been given powers to define rules, to adjudicate, and to also keep issuing guidelines and notifications as necessary to ensure that the spirit of the bill is adhered to. In the end, the harshest provision in the regulation is its penalties. So the penalties are ranging from 5 crores or 2% of your total worldwide turnover, or 15 crores to 4% of total worldwide turnover. The data principal, that is the data subject, can also claim compensation separately as a civil liability. And for certain offences, the bill is prescribing imprisonment. So that's what I had to present today, and I hand over this to the next panelist.
Excellent. Thank you very much, Krishnanand. Good morning, everyone. It's a great pleasure to speak here. I hope everyone can see my slideshow. It's brief. It's only half jokingly called "How Companies Can Stay Isolated from the Courts After COVID-19." I'm only half joking because I think it is important for us to remember that this is a pretty serious circumstances that is prevailing upon us. But at the same time, as lawyers, we do try to see the lighter side of even the darkest situation. But on a more serious note, we are a Chennai-based law firm, and like everything to do with our present circumstances, we also believe that prevention is better than cure. So I'm here to tell you a bit about what can be done in the meantime. As Krish has already explained, the Data Protection Bill is just that. It is a bill. It is not yet an act. It has not been passed through Parliament. As things stood last month, we expected Parliament to enact the law in April. But as you all know very well, the Parliament has been adjourned. The next session is tentative, extremely tentatively scheduled for the month of August. And if not, we will not have a Parliament session till December. So you may ask and you may wonder, why should I care about data privacy and protection if there is no law as such? And to that, I would like to inform you that is not the right understanding. India already recognizes what we call the right to privacy. Now, in a major case which began in 2012 and the verdict was delivered in 2017, the Supreme Court of India ruled that privacy, or the right to privacy, is a fundamental right under Article 21, which is the right to life and liberty. The case was interesting because it first started as a challenge to the Aadhaar and the use of Aadhaar by the state, by private entities, and so on, and how biometric and other data information would be used or misused. Now, the case then assumed a slightly more significant proportion when the court itself was called to decide whether privacy is a fundamental right, because the Constitution of India does not declare privacy specifically to be a fundamental right. But the court unanimously, and I believe rightly, held that privacy should be considered. And if you see the two justices that I have quoted here, and I'm vaguely paraphrasing them, the first one, Justice Chandrachud, he declared informational privacy. He spoke about how data-related technologies were all, and including big data, and the challenges that they would pose to privacy today. And Justice Cole, in a concurring decision, speaks about not just the need for regulation, but also how data is being used by non-state actors, which includes companies, NGOs, anybody who is not defined as a government entity. So it is important for us to remember that even though the law is not yet passed on data protection, the right to privacy judgment, as well as some other laws under the Information Technology Act, squarely apply to every single company today in India or doing business in India, which possess data, and especially sensitive data. And I will dwell on this very briefly as well. Now, sensitive personal data or information, and again, Krish has pointed out what is already in the draft bill. So I will not go over this again extensively, but I have pulled this out of the information technology rules in 2011. So sensitive data includes passwords, physical, financial information, biometric information, and so on and so forth. Of course, the exemption to this is anything that is publicly available or anything that can be accessed through an RTI application. Now, what the rules or what the Information Technology Act already requires companies to do, or what they define as body corporates to do, is that they require you to have a detailed privacy policy. So the first question every company should be asking today is, do we have a clearly defined privacy policy? And these 5 points sort of give what is expected by the law of the land in terms of having a good privacy policy. Again, I will not dwell on this because Krish has covered some of this to an extent. So the key is for us to understand that the law already applies to us. There is a concept of personal data, sensitive personal data, and it is important for companies today to have privacy policies and to display it prominently on their websites and other places. So what good is a law if there is no deterrent? And in legal parlance, we usually look at this as duties and penalties. Now, when you collect data, it could be data that involves personal information or a bank credit card or some other information that is sensitive to a person, or some other information that can be used to identify a person. Even information that you gave when you registered to this webinar, that constitutes sensitive information. Now, when you collect that information, the responsibility is on the collector to make sure that they obtain the consent. Secondly, it is also important that the data that they collect can only be used for a lawful or legal purpose. And finally, and fairly importantly, you need to ensure you have a number of information security policies which provide safeguards against the usage, or rather the leakage of data. Now, a very quick look at the penalties of what may happen if you fall foul of the law.
Sorry,
two sections.
Sorry, I don't mean to interrupt you. I'm very sorry to break your this thing. The slides are not on full screen mode, so people cannot see your content actually. I'm so sorry to interrupt you like this.
Not at all. Let me.
Manu, hi. Hello? Manu, can you hear me?
Hi, am I audible? Yes.
All right, just one moment, please. Right, we can see your slides, but not on full screen.
Sorry, hold on a second.
Yeah.
Is that better?
Yeah, it's on full screen now. So sorry. Thank you very much. Thank you.
I'm really sorry. I was just talking about the right to privacy and sensitive personal information. Everyone who's listening, I think my PDF is also shared under the handout section, so you should be able to download it and look at it later. I was just talking about the penalties that may be imposed if you fall foul of the law, and specifically the Information Technology Act under sections 43A and 72A. 43A is interesting because it talks about the kind of damages that can be imposed upon. And the interesting thing to note here is that there is no limit or cap to the damages. So really, anybody can sue you for loss of their personal data and claim any amount of damages. In some cases, we've seen in Europe and the United Kingdom, this goes to millions of dollars. 72A specifically talks about disclosure of information without someone's consent. The person who's providing you the information, if you do not get their consent and you disclose that information to a third party, then you could face a jail term of up to 3 years. So it is not an insignificant penalty according to Indian law. And the fine, 5 lakhs, does not seem like much, but really the imprisonment is quite serious. Now, there are just a couple of things that I thought, as a company, as a firm, what can you take away from this particular webinar? Now, if you have not already looked at the data protection bill, if you've not looked at the Information Technology Act and rules, then these are the 2 or 3 points that you should really pay attention to. Firstly, you need to let all the people from whom you've collected data, let them know about your data practices. You should preferably have taken prior consent from them for use of their data. If not, you should get consent from them now. And you should prominently publish your privacy policy on your website or such. Now, according to the Act, you should have placed some security safeguards to protect and to mitigate any loss or disclosure, unauthorized or otherwise, of these of the data. And if you haven't already done it, you must get some legal advice. And as Krish has said, you should invest in your team, train them as data protection officers, and which is a common practice across the world today and will be required to do so once the Data Protection Act does come in place. So really, this is your opportunity to future-proof yourself against the Data Protection Act. And finally, I'd like to sort of sum up by telling you a little bit about a recent case in the United Kingdom. We do look towards the United Kingdom for much of our work because the Data Protection Act is much more evolved there, and there's a lot of legal disputes which have been held, and the Indian courts draw precedent from them. Now, W.M. Morrison's is a big famous supermarket chain across the United Kingdom, worth in the billions of pounds. And one disgruntled employee of Morrison's by the name Andrew Skelton, he was holding a grudge against his employer, and he was unfortunately given the task which dealt with using the personal information of close to 1 lakh employees, which included their payroll information, their bank accounts, so on and so forth. So Skelton, who was very unhappy, went ahead, stole this information and put it online. So a number of these employees who were quite aggrieved by these actions came together with a class action suit against Morrison's. And quite interestingly, the lower courts ruled that Morrison's had to pay all the claimants the amount of money, that Morrison's was liable, even though Morrison's didn't directly do this act, and it was done by an employee who had a clear motive and a clear grudge against the company. However, last week when this matter reached the Supreme Court of the United Kingdom, the court held that Morrison's was not liable or cannot be held liable. And this is important for us to understand, because if you task an employee in your company or organization to do something which involved personal data, and today, as we are all sitting and working from home, there's so much data that is being transferred remotely out of the office space into homes of your employees and associates. It's important to understand how this information leakage or unauthorized disclosure could harm you. So what's important to know from this case is that the Supreme Court held that the employer, Morrison's, as such, was not liable because the act of the employee to leak that information was in no way connected to the actual work he was authorized to do. And secondly, that there was no concept of vicarious liability in the Data Protection Act. And I believe the Indian draft bill also does not have the concept of vicarious liability. But most importantly, this is the only thing you must take away from this case, which is that Morrison's were able to show to the court that they had met the basic legal standard of care. So they had already put in place reasonable safeguards and security measures against loss of data. So that is what helped them escape a multi-billion-dollar suit. And I hope that is what all the companies in India will do as we wait for this data protection bill to become a law. So thank you very much.
Thank you, Manu. Margaret, I'm just moving to you. Give me one moment, please.
Can everyone see my screen in full screen?
Yes, Margaret, we can see you in full. We can see the presentation on full screen.
Thank you. Thanks, everyone. Welcome, thank you, and thank you to my colleagues Krish and Manu. So I'm going to speak to you both as an Australian practicing lawyer. I consider myself to be quite strong on privacy law because we run a health services company, and privacy law is central to everything we do. I have conversations with CEOs, executives of public and private hospitals in Australia, Dubai, around the world every day, and we always end up talking about privacy. So it's an area I spend a lot of time in. But I'm also going to speak to particularly the Australian companies more pragmatically as just a business owner, an Australian business owner with a private limited company in India that I've been operating there for many years. So I'm going to switch between being a lawyer and just being a very practical business person, giving you some tips. So the first thing that I want to say, I'm just trying to make my screen go to the next slide. I've just got my screen stuck at the moment. Sorry, everyone. Give me 1 second. Okay. Here we go. The first thing I just want to say is that the introduction of this bill is great news for Australian companies doing business in India. So, look, I was looking for a sort of a kitschy slide there to sort of, you know, communicate celebration. That's the best I could come up with, you know. I am absolutely personally delighted that this has progressed, and despite the fact that COVID is going to set it back, obviously, till perhaps August, perhaps December, I don't know. The passage of this bill is something that I have been following for many years, have quietly advocated for it behind the scenes, and all Australian businesses should be very, very excited about this. The reason is this. This is a map of the data risk scales around the world. I'll give you the link. I've got another one of these maps later on in my presentation. Because what will happen is that India, which you can see there is an orange colour, is going to move into that lovely shades of yellow and green. And Manu's quite right, that privacy is recognised in India and has been certainly the whole time I've been doing business there, which is 10 years. There's provisions within the Information Technology Act, but unfortunately they're not very robust. There's not a lot of enforcement. And even though we've also got this wonderful statement, judicial statement from the Supreme Court after the Aadhaar case a couple of years ago, whilst there's a recognised right to privacy, what I've learned as a business owner about privacy is that privacy is only as good as enforcement, its ability to be enforced. And if there's no enforcement, it really doesn't have any impact. But the other thing is, certainly for Australian companies, they're very risk averse, and they're not even, privacy from my experience, it'll be different depending on the industries you are in. If you're not in the health industry like me, it may be a lot easier for you. So it depends on your industry, but reputational risk is the key thing that Australian companies want to avoid. Nobody wants to be on the front page of the Sydney Morning Herald. So that is the issue. So and this has been my biggest challenge over the last 10 years, standing in front of organisations in Australia, telling them that we have an office in India and that yes, health data is going to be handled in India, being very open, honest, transparent and upfront about that always, and watching their reactions. And then the work that I have to do to reassure them that I've done everything I possibly can to make sure that their data is going to be safe. So by moving India up the data risk scale, the global data risk scale, and moving it into the yellow and green zone is going to be absolutely wonderful for all Australian companies. Just looking a little bit at some of the similarities actually between the new Indian bill that Krish has taken you through and our current Australian privacy law. So Australians in the room, you can just have a look at that now. You will be familiar with that. So we've got the main act, which is the Privacy Act 1988. Federal, we had the major changes in 2012. We had a 2-year lead time before they commenced. It was the biggest change to privacy law in Australia in decades. And then we moved to notifiable data breaches a couple of years ago as well. I also have to comply with state health record privacy legislation, which is more onerous than the Federal Act. And there's also contractual requirements. But what you'll see over on the right of my screen there, the scope of Australian privacy law, which is guided by these Australian privacy principles, known as the APPs, are actually very similar to what Krish described. Because they deal with areas of transparency, collection, use, disclosure, transfer out of the jurisdiction. Now, I'm coming back to that. use and disclosure, security, access and correction, and dealing with complaints. And a lot of what Krish said is actually very similar to Australian privacy law. So, but you know, the fundamentals are only collect data that you have a legal obligation to collect and a legal right to have. If you have no use for the data and you shouldn't have it, don't hold it. You know, some of this is very common sense and basic. When you're dealing with sensitive data, the new Indian Act has the same requirement as Australia, which is you actually have to get active consent, not passive consent, if you are dealing with sensitive information, and that will, in Australia, that deals with health and banking records. In India, you saw from Krish's slides, there's a broader range of data that is captured under the sensitive data. So what that means practically is that you can't just have a privacy policy on your website. You can't just have a privacy policy on your front desk. We can't do that in our business. We deal with sensitive information. So you have to get active consent. You actually have to make people click to say, yes, I agree to your privacy policy. I've read it, I agree to it. Or if they walk into a medical practice, you actually can't just look at a privacy policy on the front desk. You actually have to sign that you've read it and you've agreed to it. So it's a more onerous level of getting consent. And we've got the two types of data, which is personal data as well as sensitive data. Now I'm just going to come back to transfer out of the jurisdiction, because this is the stuff that I think is going to be quite challenging, but it's also quite exciting in many ways. But the problem you'll find, we deal with data security not just under, well, it'll be the new Indian bill, but certainly the new, all the Australian acts, but we have to deal with the GDPR for our clients in the European Union. We also have to deal with HIPAA, the Health Information Portability and Accountability Act in the United States. And then we have to deal with all these laws in the United Arab Emirates. So I'm dealing right at the moment with a health authority in the Middle East who doesn't want to take their health data out of the Middle East, but our system that they want to use is hosted on Amazon Web Services cloud platform here in Sydney. So these are the sorts of challenges that we're all going to have, I think, because every country is trying to control and manage data privacy appropriately, properly. It's exciting that everyone's taking it very seriously. The problem is if they get too restrictive about you have to keep data in our jurisdiction, that just isn't going to be possible. It already isn't possible, and it's quite challenging for businesses like ours, where we've got data hosted in AWS Sydney and someone in Dubai wants to use our platform and says you have to host it in Dubai, and we say, well, we're not, because you'll put us in breach of our Australian obligations then, because the Australians say we have to keep it in Australia. So these are the sorts of practical challenges that businesses have. So if you're looking at cross-border data flows on the screen now, that's taken from the Office of the Australian Information Commissioner, and again, another similarity, the Data Protection Authority. I've had a look at what that's going to look like in India, and it's very similar to the Office of the Australian Information Commissioner in Australia. And that will be the key sort of quasi-judicial, commission that will oversee the operation of Privacy Act. What you can see there in front of you are the key points that in Australia you have to be thinking about. You're sending data to an overseas recipient. Up until now, I've had to do that through contracts. So basically what you have to do is you have to create these contracts that basically put or embed the Australian privacy framework in a contract that you get other people to sign. We have that in our employment contracts in India and so forth. But this is going to be much better because you can say, well, look, India's got a very robust privacy framework. It's as robust as the United States, and it just makes some of this a lot easier to manage on a day-to-day basis. We deal with privacy all around the world. India, Australia, HIPAA, GDPR, UAE, everywhere. And what you can see there, this is another one of these maps, and there's the link there to this organisation that keeps all the world map data security and privacy. And here they look at, this one shows regulation and enforcement. How hard are these laws enforced? And you can see that Australia's got a very good regulation and enforcement. India currently is green, so it's quite limited. So it's not to say they don't have some privacy law, but it's not regulated other than in the Information Technology Act and not well enforced. But this is all about to change. So, you know, India will move into the red one, which is great. But one of the challenges I think that we are going to find that jumped out at me when I was looking at the new bill is that what's there on your screen, which is the India bill requires a certain copy of critical personal data be stored in India. Well, of course, that's going to be challenging. It depends on the data. I mean, it's only data that belongs to Indian citizens that it applies to, so that doesn't apply to my clients at the moment who are in Australia. But the whole issue of cloud hosting of data, having different components of data in different places and different applications at different times is very difficult. So, for example, you've got an app and a big system. And our app, we are dependent on Apple, the App Store. We're dependent on Google Play. We're dependent on a whole host of other applications, as most tech companies are, that are all integrated into these really cool apps that people use on their mobile phones. But that data doesn't sit in one place. It moves around the world while it's being, while users are tapping away on their phones. So some of these issues I think are going to be the ones that will need further thought and will be developed as the new Data Protection Authority builds its capability. But look, just very practically, the way I've managed this for a decade, and hopefully this will help. This is my standard privacy slide that I've shown to, I've lost count of the number of CEOs of public hospitals, private hospitals, government agencies around Australia and the world about what we do. So we have compliance, we have administrative safeguards, technical safeguards and physical safeguards. And they are rigorously enforced. Look, the other thing that we've done, and I really can recommend it very highly, I promise you, they're not paying me to say this, is ISO certification. So we are ISO certified, and it's the highest international standard of data information security in the world, ISO 27001. Very, very, very hard to obtain, I promise you that. It nearly killed us. We've achieved it 2 years in a row, and it has made us a better business, because you have to know where every scrap of your data is at any moment in time, and where it moves and who has access to it and how you protect it. And in addition to that, you have to have disaster recovery and backup and so on and so forth. So I guess my takeaway messages are to the Australians listening, it depends on your industry as to how much this will impact you. The first thing to be looking at is, what data do you have? Is it personal? Is it sensitive? Where is it? And how much of it do you have? And then the next things are, you do need to be looking at you know, your privacy policy and having privacy officers and so forth, and getting some professional advice on that. But I also do highly recommend ISO 27001, because you'll find that if you're already compliant with Australian privacy standards and you've already taken it very, very seriously and are ISO 27001 certified, you will almost certainly be compliant with the new Indian bill when it is enacted later this year. So I'll leave you with that. Thanks very much.
Hello, so thank you, Krishna, Anand, Manuraj, and Margaret. Can you hear me? Is this audible?
Yes, Pachola, we can hear you.
Yes, we
can.
Oh, good, good. So thank you to our three speakers. I thought that was a brilliant overview. And I wish, you know, we could all unmute ourselves and give you a huge round of applause. Thank you for keeping it crisp and including, I think, all those areas that the audience would like to hear about. So I'm sure it took a lot of time trying to condense a huge subject into 7 minutes. So thank you for preparing for that. We now move on to the question and answer part of the webinar. Can I encourage all of you to please send in your questions, and Jugal from SKP will read them out and pass it on to the speakers. So Jugal, over to you.
Thank you, Pajula. We have a couple of questions that have come up. I'll just take them one by one. And between Krish, Manu, and Margaret, I leave it open to you all. The first question that we have is a very generic question. It says, why does the government want data from corporations, and is there anything that the government specifically intends to do with this data? This question is very generic in nature. Would any of our speakers want to give some initial thoughts?
Look, I'm happy to comment. I think, is that okay? Shall I go ahead and comment?
Yes, please go ahead, Margaret.
Yeah, look, I would defer to my Indian colleagues about, because I think they're better placed to respond to a question about the underlying intention of the Indian government. But from my perspective, I don't really see this as the government wanting to collect data. This is really bringing India in alignment with other countries around the world in terms of the way they protect data. So data privacy globally, including the GDPR, which was enacted last year and is very onerous, it is not intended to prevent cross-border data flows. We all know that data flows across borders. As I said, every moment of every day, our data is flying around the world, including our banking sensitive data, despite what we might think about it. But it is really more just to put a regulatory framework around the way we handle data to help citizens take it seriously. That's the first. But also to give businesses confidence working with other countries when they're confident that the country is taking the issue of data privacy very seriously. So I don't look, I could be wrong, and Manu and Krish might have something to say. I don't see this as the Indian government trying to collect all our data and keep it. It's really more about bringing India into the modern world of robust privacy framework.
Just if I could add on to that, please, Margaret, and I think you're right, and I agree with all of what you've said. I don't think it's a question of government being interested in our data specifically. Perhaps in the context of Aadhaar, that's what the case was, is to understand what is the objective of Aadhaar, and the government was able to convince the court that Aadhaar was necessary and essential to provide welfare services for 1 billion people plus, and that's why it was required. But really, most of the last 10 years, we've heard this again and again, which is that data, big data is the new oil, and not just the government, every entity wants to collect data and wants to put good use to it. As Margaret has pointed out, and as Krish has touched upon, what the Data Protection Bill does, which the Information Technology Act could not do effectively, is to put in a robust regulatory architecture which will control and which will oversee how data is being transferred, used, and misused. Just to add on, even
So to add on to what Manu has and Margaret have put across, most of us don't realize that we are living in a digital environment where you're forced to make choices without even realizing that you're profiled and tracked online for every action that you do on the internet. And it is a very different world that we are living in. So we are made to believe that we are making appropriate choices, but it could not be true. From the time you book a cab, Uber or Ola, to the time that you log on to the internet and look at an e-commerce site, every action of yours is being profiled online. It's being targeted, and individuals are made targets by marketing companies. It is high time that we as individuals also get a chance to make informed choices, not make-believe informed choices, but informed choices in the true sense. So data protection bill is one step towards that. And if you really look at data protection in India, it has always been there. So RBI already has some things around sensitive personal data and also some things around personal data as a regulatory body. The telecom industry is already regulated through the Telecom Regulation Act, where they need to take care of data privacy and also the privacy of the call details and the other details that they collect in terms of offering services to the end customers. The healthcare industry is also already regulated in India, so is the insurance industry. So, in the truest sense, this is not a new introduction. It has always been there and it was always being regulated, but it was specific exposure to an industry. What this bill has brought into play is empowering an individual citizen control over what information of his is he willing to share and what is it that they feel should be kept personal to them. So it's just an empowerment, and taking it in the right spirit. Government really is not interested in our data. So I think that completes the circle. Jugal, next question.
Thank you. Thank you, Margaret. Thank you, Manu. Thank you, Krish, for your comments. Another question is, international companies that are operating in India but are not ISO certified, what is the biggest impact that the bill will have on these kind of companies? Any comments?
I can answer this question. So ISO certification is just a good to have. Being an ISO certified company does not guarantee that you are a company that adheres to data protection policies. ISO framework in its current form just addresses information systems security. It does not address privacy and personal information management. There are other standards which do address that. The closest is the BS 10012, which does speak about privacy and data protection. And that is a more relevant standard in terms of privacy data protection framework. DSCI, Data Security Council of India, has also come up with a privacy data protection framework divided into 16 domains. It has taken the best practices from NIST, from learnings from GDPR, and some learnings from ISO 27702, which is a newly introduced standard on data protection. So companies in India who are not ISO certified, they need not be so worried about it. ISO 27001 was a recommendatory certification under Indian Information Technology Rules, SPD 2011. Again, it was a recommendatory certification, but it does go a long way to demonstrate due care. Taking cue from Manu's closing remarks, but a better and more effective way of showing due care would be that we need to adopt frameworks which are more attuned and relevant to data privacy and protection rather than an information security framework.
Can I just make a comment there too? Thank you for that, Krish. I absolutely agree with everything Krish has said. One thing I would just say is that as an Australian company who has to deal with this all the time, certainly the government agencies I deal with. So as I said, this may be different in different industries, but certainly a lot of the government agencies we deal with in Australia and the tenders we are involved in require and ask for ISO 27001. So certainly it matters at the Australian end it may not matter as much at the India end, and Krish is the expert here. So, he's described a whole host of other standards. But as an Australian company, I'm almost every day required to provide information about the way we manage our data, and that every hospital in this country, 27001 is the standard. 27001 means something to them. 27001 has helped us enormously. And in fact, I am now going to go and look at the other standards that Krish has pointed out, 27002, because if that's available, I'm going to jump on that as well. So what I can say is that at the Australia end, ISO matter a lot.
Thank you, Krish and Margaret, for your remarks. We have one more question. This question is in fact from the chamber. How will this particular bill affect the provision of the Right to Information Act? Do you have any comments to share on that? If I may read.
No, it's a very valid question. So what happens to RTI Act where we seek information about individuals? Will this bill become an impediment to that? Is that understanding correct?
Yes, so I think basically what the person wants to understand is how will the PDP bill act basically imply with the RTI Act? So is there any correlation or anything else that we need to be aware about?
Okay. So as I said, there are various provisions under various regulations and different regulatory bodies who are monitoring in terms of personal and privacy data protection in India. One of the key inputs that Nexdigm has provided to the Joint Parliamentary Committee is harmonization of rules in various regulations in India, which speak about personal data and privacy protection, so that all of that can be aligned to one PDPB bill, which its current draft form does not speak about any such harmonization. The expectation from the industry and from various people in the legal fraternity and the feeders that we have been getting is that eventually, once the Data Protection Authority is set up, he may start defining guidelines and rules of harmonization to ensure that there are no overlaps, first, and second, there would be no confusion as to which takes precedence over the other. So I think to a very limited extent, I have been able to answer your question. Since there has been no clarity on this till date, it is very difficult to comment at this stage. Manu, you would like to add to this?
Thank you. I might just add one thing, which is under the Information Technology Rules 2011, specifically information that can be furnished under the RTI Act is not considered to be sensitive personal data or information. I would assume that the same sort of regime applies. The larger question about the right to privacy remains. People and their privacy will be protected at all costs. That is the intent of both the RTI, because the Public Information Officer has the powers to exempt personal information. For example, you cannot ask the income tax returns of a person or a public servant under the RTI. That would come under personal. And likewise, even the Data Protection Bill as such, as it is now, in the form that it is now, it does place a heavy premium on protecting privacy, protecting the personal sensitive information that belongs. So I don't think there is a conflict as such. We may have to wait and see whether there is something that evolves as the bill goes through the parliamentary process. But as of now, I don't see any particular conflict. Only matters that are of public interest may be accessed. I hope that adds some value to that.
Thank you, Manu and Krish. I guess that would be the end of the Q&A round. We're running out of time. Petula, if you would just want to make the closing remarks, please.
Jugal, can you hear me?
Yes, we can.
Okay, great. So thank you very much. Thank you, Jugal. And I'd like to thank all the members of the Indo-Australian Chamber of Commerce, our partners, our friends, and whoever's attended this webinar today. So if you do have any more questions, please send them across. We'd be happy to get some answers for you from our experts. And once again, thank you to our speakers who did an absolutely fabulous job of sharing different perspectives. It's everything I hope to learn about, and I hope you found this useful too. Thank you to Viral, Jugal, and Manisha for organizing this for us. So once again, we'd love to hear from you and any feedback that you'd like to share with us, because it would help us to improve, and also to decide which topics to bring to you next. So thanks again to everyone for attending, and to SKP for doing this in partnership with us. Have a great day.
Thank you.